Items for pronouncement of judgment. Item 1, Criminal Appeals 69 of 2024.
May I mention matter before?
Please wait. First the judgment.
Appeal allowed.
Item
Hello,
number
yes, my lord. Hello.
27, WPC 416 of 2024.
Petition allowed.
Lord, may I mention a very unfortunate thing happened yesterday. My colleague, without instruction from the client, and while I was here sitting in the court, and while SP Chaudhary from the other side was sitting, we are not knowing that he previously at 10:30 prayed for an adjournment. We are not so unfortunate. I'm coming all the way from Kolkata, my lord. And this matter is very serious, my lord. I pray to your lordship, my lord. If you kindly hear the matter in the second half, other side is.
No, today we
agree.
cannot take up the matter, and also this court cannot accept your mention. You go to the senior court.
Senior
Mention there, yes.
court number 2, my lord.
Pardon?
Is it litigation matter?
Yeah. Court number 2, my lord.
Yes.
We are grateful, my lord.
May it please your lordship,
Yes.
with the counsel for, with the consent of the counsel for the petitioner lordship, I beg to mention item number 12 lordship.
12.
Lordship. Lordship may fix the
Yeah,
matter on 29th lordship.
Date time lordship. Yeah, agency is date may be fixed lordship.
On 29th lordship.
Mr. Sharma, learned standing counsel for the respondent in Elementary Education Department with concern from the other side, respondents in the matter. On
29th lordship.
29.
okay.
Much of it. Much of it.
Problem.
May I please, your lordship, with the consent of the other side, your lordship, I beg to mention item number 20. There needs a substitute petition to be filed where the petitioner was expired as per instruction from the client, your lordship. So I may be allowed to 1 week time to file.
Mr. B. N. Gogoi, learned counsel for the petitioner with consent from the other side, press for listing the matter after a week.
Lordship.
Fair allowed.
Deeply obliged.
With the consent of the petition, I beg to mention item number 13,
1-3,
1-3, madam. Matter will be taken up from the first week of June, madam.
first week of June.
Right.
Mr. Bora, learned standing counsel for
PTC, madam.
PTC. With consent from the other side, press for listing the matter in the first week of June.
That's
Fair allowed.
May I please, I beg to mention item 21 also. In this
20,
21.
I am for the respondent, my lord. I have no objection.
Yesterday we have submitted a adjournment slip actually. Yesterday we have furnished a adjournment slip.
yes,
So, lordship may fix the matter on next week.
next week.
Next
No,
week.
let
It's
it,
agreed by
no,
learned.
let it be on the first week of June, my lord.
Justice shall list the matter after a week
After you close.
No, let it be on the first week of June.
on
First week of June, in
first week of June.
June.
Okay,
Can it be on 12th of June?
12 June.
June. No,
All
no,
right.
lordship, not.
Intimate it may be.
Interim order passed earlier shall continue. Yes,
In item number 22, lordship, in here, I am for the petitioner,
Hmm.
but I have no any communication between in the petitioner. So
The petitioner
some time may be granted, I will inform whether he has been promoted or not because he
I
said
have
that-
the instruction, already petitioner promoted
and
to
he's
his
retired from
next
service.
higher cadre and he retired on 31st March 2022. Already retired, lordship.
in the item number 22.
22.
Already retired, lordship. During the pendency of the petition, he was promoted and retired on 31st March 2022.
Mr. Gogoi, you were appealing for?
I am for Asuna 2 and 3. Assam State Agriculture Marketing Board. And next one, lordship, he was promoted.
So this petition become infectious.
Yes,
So that's,
Okay, we'll close it.
lordship.
yes.
Close it.
Oh, on the basis of this record.
Yes.
Only, lordship record that he retired on 31st March 2022.
Is it not in
It
the,
is not in, it is the instruction of 2016, lordship.
retired on
31st March 2022.
22?
22.
Noblesse.
Wait, please, Lordship. But may I pray for listing of our IA, my lord? The Lordship passed an order directing the personal appearance of the director on 19th, my lord.
Mm.
Whereas, my lord, the order has already been complied. But there was some miscommunication perhaps, my lord. That was not pointed
Okay,
out.
okay.
My lord.
When?
Tomorrow, my lord.
I'm grateful. May I please, Your Lordship. With respect to item number 14, my lord, the arguing counsel, R. Chakravarti has some personal difficulties today, my lord. Let this matter come up after 3 weeks, my lord. And my lord, in the meanwhile, the higher education may be directed to file the affidavit in opposition, my lord, because that is necessary for this, my lord.
Who is for higher education? Mr. Bhuya, are you supposed to file affidavit in item number 14?
As per the last order, my lord, 5/5/2025.
Mr. Your good name, please.
S. Rabha, my lord.
Yes, Rabha, learned counsel for the petitioner. Price for listing the matter after 3 weeks.
After 3 weeks.
Yes, so Mr. R. Chakravarti, learned conducting counsel is out of station.
Not out of station, my lord, has some personal
He
difficulties
has
today.
some personal difficulties. He further submits that respondents in higher education department is supposed to file the affidavit and the same has not yet been filed. And a direction may be issued to the respondents to file their affidavit. There is accordingly allowed. Mr. Bhuya, learned standing counsel for the respondent authorities may file the affidavit in opposition in the meantime. Leaves the matter after 3 weeks.
Obliged.
May I please, Lordship? Lordship, I beg to mention item number 10, my lord.
Item
10, my lord.
10.
In this matter, my lord, government supposed to file affidavit, my lord, today, my lord. But
You have a petitioner?
petitioner, my lord.
Yes.
But my lord, matter will be taken up, my lord, after 2 weeks, my lord. We
After
2 weeks, my lord.
2 weeks. Mr. Your good name?
HP Neog, my lord.
HP,
Neog.
learned counsel for the petitioner. With consent from the other side, as for listing the matter after 2 weeks. There are
Items for admission, Parthar matter, item 2 to 6.
I pray for further 2 weeks time to file the additional affidavit. I'm informed the counsel for the petitioners yesterday
in all the matters.
in all the matters, sir. Because there is a direction from this honorable court to file an additional affidavit to bring on record all the subsequent development that has taken place after this recruitment process. Ma'am.
Mr. B. Kosik, learned standing counsel for the
Elementary education.
elementary education department. With consent from the other side, first for listing these items after
2 weeks, ma'am. Any day.
after 2 weeks. After 2 weeks, they're allowed.
Well, it may be kept as part heard matter.
It is
Partner.
already part heard.
This is a list the matter as part.
Date may be fixed by.
Okay.
2nd June.
Grateful.
Obliged.
Item number 7, 8, and 13.
May I please your lordship kindly pass over the matter for me kindly. My senior is on leave.
Item 9.
Well, in 9 last occasion, my government has taken some time to file if any counter is required, madam. Whether filing or not, I am not aware. If they are not filing, then this matter will be fixed for on next Tuesday, for final hearing, madam. That will be disposed of. They keep it in part heard.
Yes, so who is appearing for Mr. Upamunya?
Upamanya was there.
Yeah.
Lordship, he is on leave. Can this matter be taken up after some time?
After some time.
Yes, your lordship.
Why not? If it is not filing, that might.
No, respondent number 2 has already filed affidavit.
I have filed a reply.
Reply.
On that reply, last occasion, they took time.
Hmm.
Lordship will get on my lord On my lord 23-4, due Upamendra time to file the counter if necessary.
Hmm.
So that was the,
So, he is not present in the court after some time.
my lord,
If he is not willing to file the reply, then we will
Yes,
proceed to
that-
hear
that-
the matter.
yes, my lord.
Number 11. Item 11.
None appears for the petitioner of all, less the matter after 1 week.
28.
My lord, in this case, lordship in last occasion heard in length, my lord, this case. And my learned friend with PJ Fukon, his take time on that day. Regarding the affiliation to the concerned institutions for running the my lord, LLB course and BLLB course. He trying to justify one thing, my lord, when he is saying in that day, he submitted that the 440 LLB is there, he is no objection. Because when as per the, my lord, they guide this OM, where it is showing the graduate college means these are arts, science and commerce. So as the one LLB is a postgraduate course, so he said that in that aspect, they have no objection. But he raised the objection so far the BLLB is there. Because they are saying something that they are preparing the syllabus and everything is as per their minor whims. But the things is that the BCI minor under the regulation of education, they have prepared the minor curriculum. So they are the only the authority to conduct the examination, not for anything done. They are not preparing any syllabus, not preparing anything, my lord. Only they are preparing this, conducting the examination on behalf of BCI to, my lord, confer the degree, BLLB or whatever it may be, my lord. So in that aspect, my lord, the UGC, my learned friend also, UGC also saying there in affidavit that whatever regulation, UGC regulation for affiliation 2009, the same thing also they are relying. And whereby it is saying the my lord, if the my lord, statutory rules and regulation will prevail as per the my lord, affiliation is concerned. So if the regulation, what is the regulation also, they also define in the my lord, UGC regulation. Kindly, my lord, see at my regulation, my lord. In last occasion, my lord, I abide the lordship. They are also relying the same regulation, my lord. Wherever it is, my lord, the regulation, it is called, but regulation may be called the UGC Affiliation College by Universities Regulation 2009. Whereby, lordship, I will hand it over to lordship, my lord. Kindly have a look at my lord.
That is the
This-
page 42 of my affidavit.
B is also there in their affidavit, my lord. Same regulation, my lord.
Yes.
It is, my lord, regulation, my lord, 3. Eligibility for criteria for temporary affiliation, my lord.
Hmm.
Where, my lord, 3.1, it is saying that the proposed college seeking affiliation at the time of the inspection of the university shall satisfy the following requirements or the requirements in respect of any of them prescribed by the statutory or regulatory body concerned whichever is higher. Whichever is higher, my lord.
Hmm.
Here, my lord, kindly come to my lord, point 2.6, 206, just above. Where, my lord, it is defined this regulatory body and statutory body. The statutory body and regulatory body means a body so constituted by the center state government act for setting and maintaining the standard in the relevance area of the higher education, such as All India Council of Technical Education, AICTE, Medical Council of India, MCI, Dental College Council of India, DCI, National Council for Technical Education, NCTE, and the Bar Council of BCI, my lord. So, my lord, the statutory and the regulatory body, whichever is higher, but if we go to the higher, who is the higher, then, my lord, the Bar Council is a, my lord, the central regulation, my lord. And the UGC, the university regulation, whatever they are insisting that they are as per their guideline, they will go. This is a state regulation. And it is a, my lord, established rules and it is established law that whenever the two are conflicted, always the central will prevail. So as per this regulation, now come to my the BCI regulation, where I relied by the BCI regulation provisions also.
Just I would like to, just taking a cue from my learned friend. when Sentinel said, it's correct when he correctly said the legal position, to add to his, the maintenance of, normally education is a state subject. But maintenance of standard in higher education is a central subject. Maintenance of standard in higher education is a central subject, entry 66 list 1. Therefore, if there is any conflict with these state bodies, any regulations taken by the state, then the central will prevail. Therefore, whatever BCI says will prevail over the regulations of the university concerned.
So my lord, so far the BCI is concerned, my lord, where it is specifically, I have annex also and I'm specifically mentioned in my affidavit also, where my lord, it is in lordship will.
Mr. Pukon is not present today.
My lord, I don't know, my lord. He's having some problem sometimes, my lord, that is why it's difficult. The lordship will come to page 36, my lord, of my writ petition. My lord, lordship got it, my lord. And that day also I have pointed out these things, my lord. Kindly come to point 6.
Yes.
Well, in case of the state funding institutions, but it's very interesting matter, state funding institutions or institutions seeking fund from the state, oblique union government, a statement from the relevant government for no objection to the applicant or the specific preliminary approval or sanction for the establishment of the institutions. University faculty oblique department would, however, not require the same, but has to submit the resolution from the previous various authority required for the establishment of which shall also be accompanied by the act, rules and regulation of the universities, my lord. Here, my lord, my case is, my lord, is a purely private institutions. It is not, I am not claiming any fund from the government, nor any future, any probability that I am seeking for any fund or any assistance from the government. I have already established more than 5-6 institutions, that is all are private, under this foundation. And law college also, this is a private college. So in that aspect, by the regulation, BCI also specifically saying that where the government funded or state owned university, that is only required in case of the establishment of the degree LLB courses, they require the NOC from the government. But so far the private colleges there, BCI very clear that it is not required. And kindly come to next page also, my lord.
On the way. Okay.
And under the same, my lord, guideline, BCI rules regulation, my lord, this is 2010. It is whatever I relying. For lordship and products periodic inspection under the head of periodic inspection, lordship will come to the, my lord, point 3. This is the applications and accompanied by the inspection fees and prescribed and the following documents. Last 3 years of additional, but this is not required, last 3 years of the annual reports, list of the faculties, all important resolutions of the government governing body which are related to last 3 years investment in the independent, copy of the further inspection of the report of the such, list of the members and such. Then lordship will come to point 6. Copy of the affiliation letter, if it is an affiliated institution from the university, NOC from the relevant government, if it is a state-owned or the funded institutions. So it is very clear, BCI, that in case of the state-owned university or state-funded university, NOC is required from the government. But so far the private college is there, but it is not required. So my humble prayer, that I have prayed to the university to give the affiliation in respect of my private college. That was initially I applied in the March 31st March 2000, my lord, this is on 22. Then again, there was a second application that was made on 2nd May of 2022. Then, my lord, the university came with a, my lord, letter. This is in respect of, my lord, they are issuing on OM, my lord. It is my annexure 5 of my writ petition. That is on 25/2. 5 of writ petition, page number 27, my lord.
Yes.
By which they have stated that, my lord, the as per this, my lord, OM, my lord, they are not giving the, my lord, affiliation to the institutions and accordingly giving a direction, my lord, lordship.
To obtain no objection certificate.
No, this is kindly, my lord, come to, my lord, this is annexure 4, before that annexure 4. this is a letter written by them from the university. They are saying that those university or institutions or my lord, whatever my lord, they are applying for the my lord this affiliation, and they are still pending as per the OM, my lord. As per the OM, that is my lord, they have mentioned this my lord the letter by in persons of that my lord, they are not going to give the NOC, my lord, the affiliation unless and until they produce the NOC from the state government, and those cases are pending. They are directed to my lord, obtain the NOC and furnish to the director of the college my lord, development council, my lord, so that the affiliation may be granted. So in that respect, my lord, they have, I have specifically my lord annexed this document, my lord. This is a OM relying on this, on the basis of which they are affidavit also saying this, insisting on the same document, my lord, where it is specifically saying, my lord, kindly come to my lord definition, my lord, section 2, subclause 4, page number 27,
College.
page number 27. It is specifically stated a degree college means means a college imparting general education for 3 years degree course in arts, science, and commerce. So in respect of the my lord submission was this, my lord, the so far the LLB is concerned, this is a postgraduate institution, and this is a BLLB. This is an integrated course. It is nowhere, neither come under any stream of the commerce, arts, or science. So this is a purely professional course. So this will not cover the degree college definition, is not covering my college, my lord. So this also not applies in my case. And kindly come to their affidavit, my lord. They have what they have stated, my lord, in their affidavit. University, my lord. Yes. That is where they have filed on 29/9/2022, where lordship will come to straight pay, my lord. This is in their affidavit, para number 3. Lordship got it, my lord?
Got it.
Yes. In para number 3, they with regard to the statement made in paragraph 1, 2, 3, 4, and 5 of the aforesaid writ petition, while putting the writ petitioner to the strictest of thereof, this deponent humbly beg to state that the petitioner has applied for the NOC and provisional affiliation of LLB and BLLB of course to the Guwahati University Authority. In the name of the foundation, it is stated that the relevant BCI regulation is a regards to the state funding institutions or institutions seeking fund from the state. It may be pointed out here that since the office memorandum of, it is very important, but Govt of OM Assam issued on such and such February 2009 was meant for the affiliating university, the executing council EC of the Guwahati University in its meeting held on 29/3/2029 had decided to issue the council as a party circular as per the OM of the Govt of Assam. It also stated that the Guwahati University is an autonomous affiliation, but both statements are contradictory. They are saying one side that this is an autonomous body, but they are on the other side, they have taken a stand. They, as the government has issued this OM on the basis of they are not declined, they are not inclined to give the NOC affiliation. So if there is an autonomous body, what is the necessity of taking stand of this minor? Their affidavit itself is a contradictory, my lord. So my humble prayer is this, my lord, this affidavit will not stand in support of their case, because their support initially from the very beginning, my learned friend, my lord, from the Guwahati University stated that they are the autonomous body, they have the power to do anything, my lord, whatever they like. But whatever may be, my lord, everything is to be in consonance to the UGC regulation. And UGC regulation 2009 affiliation, my lord, specifically said under what provision, my lord, in what way that will be given. And moreover, my lord, whenever they are stating that our autonomous body, then what is the necessity of relying on this banning of this OM? So everything is, my lord, as the dictation of the government, my lord, not by their own. So my humble prayer is, my lord, this is affiliation, provisional affiliation may be granted, my lord, because I have already formulated, my lord, getting all the, my lord, fulfill all the requirements, whatever is under the BCI rules regulation. And this, I have deposited money, 6 lakhs to the BCI for the approval of the course. So in that aspect, my lord, I am suffering because of this, their reluctant attitude of the Guwahati University. So my prayer is, my lord, this should be considered and this may be allowed, my lord. My petition may be allowed, giving a direction to the Guwahati University to give a provisional affiliation. Because the whatever they are relying, nothing is supporting their case. One way they are saying that their body is an autonomous body. If there is an autonomous, what is the necessity of relying on banning on this OM government issued by the government in 2019 as well? And my application that was on 31st, first one, then against that 5/2022. And they come with another notification that is on 24/5. That is also mass after my 2 applications. So this is not applicable to me. That may be applicable to the government institution or other thing. I have no objection. But the so far the private institution is concerned, my college, my institution. The BCI also saying the same thing.
You have applied for affiliation prior to the OM.
No, OM was in 2019. I am not aware this OM.
Okay.
But they are relying the OM in by their notification. And the affidavit subsequently came in support of that. This letter they rely, the Annexure 4, on the basis of that they have filed the affidavit. This is 24/5. And so whatever may be, my lord, presuming that this regulation comes under this and provision, then OM also applicable. But so far the private college is there. The BCI also saying, and the UGC, my lord, affiliation regulation 2009, it is also very clear. That the regulation, whichever is higher, that will prevail. And in my case, my lord, BCI regulation will come, and that will prevail over everything. Because we are not conflicting with the UGC regulation and the BCI. The whatever stand is taken by the UGC, same stand was taken by the BCI also. There is no conflict. But so far the university personnel, their stand is there, this is conflicting. And I am not submitting anything, but there is a reasons for why I have been refusing. It is a different reason. I am not going to express these things, But as per the rules, regulations, and document relied by me, and the affidavit also given by this UGC and the university concerned, it entirely support my case, except by the university concerned. So my prayer, there is no impediment in issuing the affiliation in my favor, so that I can go. But students are suffering; they are all waiting, everything is ready. Classrooms are ready, staff's rooms, the professor has been appointed, They are also getting salary.
Mr. Somoa, what is your stand?
But my stand, as such, actually, we have issued the guidelines. And according to that guidelines, the universities are to affiliate the colleges. And so far as the University Grants Commission is concerned, it says, that if it comes within the periphery of that guidelines, then they are entitled to. But so far, my understanding goes after hearing from the Learned Council from the other side. It is the university, Guwahati University, taking guard of an OM issued by the government. They are not issuing the affiliation letter. So now, it's better they can explain why that OM and if the university itself is an autonomous body, whether they can be guided by an executive instructions of the government. That is the most plausible questions that the Lordship has to decide. The office memorandum of the government is an executive instruction. That is what we call in legal language executive fiat. If that executive fiat, whether it can control the affiliation subject matter of an autonomous body like university. Guwahati University is a state university. If they want to do something, bring something new, then they have to amend the Guwahati University Act. Until and unless they amend the Guwahati University Act and rules frame thereunder, by an executive fiat, I believe, my lord, that cannot be. And even if that OM is issued, if it is beyond the guidelines issued by the University Grants Commission, then also it is difficult. Then also it will be stuck down. Because the maintenance of standard in higher education, as I have said, this is a central subject, union subject. And I believe to decide at a very just decision of this issue, friend from my the opposition in Guwahati University and BCI, both of them to be heard. BCI has not yet filed their affidavit. Therefore, my lord, in my respectful submission, if Lordship, I'm not praying on their behalf, but I'm just pointing out as an officer of the court. As an officer of this court, my lord, until and unless they make their stance clear, it may be little difficult to arrive at a very judicious decision, my lord.
Why?
Because they are the stakeholders. They are the eminent stakeholders. As University Grants Commission, my lord, we issued the guidelines. Now, as to what level they are following the guidelines and what is their stand, why they are refusing to grant the affiliation. And one more thing, my lord. Whether a private body applies for an affiliation to an university, only because they have applied, whether it is their statutory right to get the affiliation, whether it is the university concerned to affiliate or not to affiliate, this is also there. Therefore, my lord,
Yes, who is for BCI? Who is your senior? Okay, then.
there are P. Mohantos and I am being
Both
sentenced.
sides. No, BCI, my lord, he earlier occasion also he is saying that they have nothing to say because whatever they will say, this is as per the BCI guidelines. And whatever theirs, whatever will come out, I have already submitted before lawsuit. This is the only.
Okay.
Well,
Let them come, Mr. Soma, you can leave. You
My
can go.
My lord, I am blessed.
and so far the money is concerned, BCI has taken the money 6 lakhs. It is I have affidavit. I have.
On the other day, you have submitted it.
Yes, madam. 6 lakhs is already
Okay,
deposited. They are taking the money.
Let the
BCI.
council for BCI and University Cup.
For bail hearing,
My lord, then, my lord, this is concluded, my lord.
On your part, it is complete.
Well.
Let the other side come.
My lord, I hurried to be, get the at least some response
Okay,
from the
okay,
court
we will
because, my
see.
lord, there is a approach of the petitioner to the Supreme Court also. The direction was given from the Supreme Court as well, my lord.
Lordship will take it up immediately after some time or on a different date.
No, your presence is not required. I have
Yes,
already
yes,
heard.
someone.
You can.
for bail hearing, item 15.
Tadi mati ay.
May I please, Lordship? Lordship, in this case, earlier granted bail, my lord, to the petitioner. Subsequently, during trial, he is absent for 1 day. On 4/3/2025, he was absent. And accordingly, NBW was issued and he was arrested, my lord. Now he is in 43 days in custody, my lord.
For
43 days,
15 days.
43 days. And earlier, we approached the landed court below, my lord, as page number 25, where is cleared there, my lord, he is absent for 1 day. Page number
So
20.
why you could not appear on that day?
Lord, as per information, my lord, he is on, due to illness, he could not appear and landed.
Whether you have submitted any medical document?
No, my lord, that
No.
was not
Then-
submitted.
What is this the case is pending?
For evidence, my lord.
Whether any witness have been examined?
Two, as per my instruction, two witness examined,
Two witnesses are examined.
lord.
In this case, scan copy to receive, scan copy not yet received. Scan copy was done.
Earlier, scan copy was called for as per my instruction, yesterday it was received by the section man.
But today is not my lord tagged with record, my lord.
Okay, as per office note dated 13/5/2025, a scan copy of the record has not been received.
My lord, I have said yesterday it was received by the section, my lord. If possible, tomorrow, my lord.
But why the notice otherwise? 13.
Was this was prepared before that, my lord, so.
Okay. Okay. So let it be tomorrow then.
Lordship.
Pardon me, sir, R. Ali, Learned Counsel for the petitioner.
H. Ahmed.
H. Ali.
H. A. Ahmed.
H. Ali.
Ahmed.
H. Ahmed. Okay. But on the other day, someone else appeared,
Lordship.
but early appeared. Learned counsel for the accused and Mr. Borthakur, learned additional PP for the state respondent. Office note dated 13/5/2025 indicates that scanned copy of the record has not been received from the learned trial court. But Mr. Ahmed, learned counsel for the petitioner, submits that as per his instruction, the record has been received by the section yesterday. Accordingly, it is provided that the shall release the matter tomorrow, enclosing the scanned copy of the record.
29. 29 also, my lord, scan copy not yet received, my lord.
Not received. None appears for the accused on call. However, Mr. Portacle learned additional PP present. Office note dated 6/5/2025 indicates that scanned copy of the record has not been received from the learned trial court. It is accordingly, it is provided that REST shall issue reminder to the learned trial court for transmitting the scanned copy of the record along with the up-to-date status report without fail. Please the matter on.
19, 20, 22nd. Item 16 for orders.
May I please your lordship? Is content matter notice was issued on 12/5/2023.
The order has been complied.
I have seen the.
You have seen.
Yes, my lord.
You want to challenge this order then?
Yes, I am going to challenge.
Okay. But then we close this
Yes, my lord.
hardness of
Lordship, I record the name of Mr. B. Kaushik, Lordship.
And copy of the death order is not furnished to me and.
I will.
Okay. Then also heard Mr. B. Kaushik.
B. Kaushik.
Learned standing counsel for the complainant. During the course of hearing, one order dated 5th November 2024 was produced before this court by the learned standing counsel for the respondents and submits that the order of this court dated 28/10/2022 has been complied. Ms. Rosal, learned counsel for the petitioner, submits that granting liberty to the petitioner to approach this court again by challenging the order dated 5th of November 2024. This contempt case may be closed. There are taking note of the submission of learned counsel for both the parties. This contempt case stands closed, granting liberty to the petitioner to approach this court again by appropriate petition, by filing appropriate petition. Challenging the order dated 5th of November 2024. The order produced before the court shall be part of the record. A copy of the order be furnished to Ms. Ozargora during the course of the hearing.
Obliged, my lord.
16, 17.
17 also content matter. Notice was issued on 29/4/2020, 29/2024, my lord. No affidavit have been filed, my lord. This is a secondary education, my lord.
So, who is for secondary education?
Order was passed
Lordship,
on.
here, name is not from Lordship. Lordship may fix perhaps.
Madam, there was a direction for taking step.
Lordship.
I have already taken step, my lord.
When?
Then yeah, second.
Neither edit card nor answer notice received.
Then I will take for fresh session.
Best system. Hard is A. Buzarbora, learned counsel for the petitioner, and also hard. None. Counsel for the petitioner. Office note dated 13/5/2025 indicates that neither edit card nor answer notice issued to the respondent number 1 and 2. Receipt back. Ms. Buzarbora submits that she will take best receive upon respondent number 1 and 2. There is allowed. Step be taken by registered post with KD and also by the process within a week of the time. This is the matter. After 4 weeks.
Items for hearing, item 18, partner paper.
Matter may be taken at 2 p.m. Lordship. Counsel for the appellant is on the way to Guwahati from Nalbari.
Who is the counsel?
Lordship.
Who is the counsel?
UV Sharma. UV Sharma.
Not today then. Look, put this. He is in Nalbari Manase. It is not supposed to come here from Nalbari. Next week,
Otherwise fix another date.
You take 20. Another 15 minutes.
20. As agreed by learned advocates of both the parties, recessal is the matter on 20.
Item 19.
Sir, may kindly pass over this matter for time being. My senior is on legs on code number 10.
Who is your senior?
What?
Who is your senior?
R. Majumdar.
After review petition, the matter for the first time today listed my lord before the court. So I want some, I may be allowed to some accommodation for today, my lord. Because my lord, a review of that has been disposed of in 2021, then they have filed a review petition. After review petition, my lord, that is for today listed for hearing, my lord.
Okay.
So kindly, my lord, accommodate for today only.
Art Miss?
S. Barbujari.
S. Borpuzari, learned counsel appearing on behalf of Mr. R. Mazumdar, learned counsel for the petitioner, and also Hard Miss Gaya. Learned, you are appearing as?
CGC for the respondent, my lord.
Learned CGC for the respondent. Ms. Gaya submits that the matter may be listed after?
After 2 weeks, my lord.
After 2 weeks.
Yes, ma'am.
So as to enable her to go through the record.
Yes, ma'am.
Fair, look, let's establish the matter after 2 weeks. This is of 2014.
14 matter that has been already 2021 that has been disposed of. They have filed review petition, my lord, and review was allowed, my lord.
Okay.
First obligation.
23 and 24.
Fine. None appears for the petitioner on call. However, Mr. Parthakur, learned additional briefing present. Lays the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
25.
The time being. Time being. Senior.
Okay.
26.
Lordship, in this matter also Mr. R. Majumdar will be appearing. Can he be taken after some time, Lordship?
R. Mazumdar?
Yes, Lordship.
Okay.
After some time. Nice.
31.
None appears for the petitioner on call.
31.
I'm appealing for the state.
State. None appears for the petitioner on call. However, Mr. Soikia, learned
Mr. Kumar, Your Lordship.
standing counsel for the
I'm K Kumar, Your Lordship.
war. Okay.
Yes,
Mr. K. Kumar, learned standing counsel for
additional AG, Your Lordship.
learned additional AG.
Yes, sir.
Additional AG. Learned additional AG. For the state respondent present. List the matter after 1 week.
Lordship. Obliged.
Pending matters 7 and 8.
What are dated 23/4?
My lord, may I draw my lordship's attention to the order dated 23/4, my lord. Is that matter, my lord, regarding non-payment of salary to the petitioner despite, my lord, two orders, my lord.
Okay. In this matter, my lord, I think on the last occasion, impediment is supposed to be filed, my lord, regarding the finance department. Lordship, number 7, my lord.
My lord, may kindly peruse the order, my lord. What is on 23/4?
Today, the impediment has come today, my lord.
That is a
Impediment-
different issue, my lord, because what we have done, my learned friend, Mr. Chaliha, is accusing us, my lord, that in the petition, we have not implemented the finance. Without, my lord, implement, my lordship has proceeded with the matter and they are seeking instruction from the finance. That, my lord, the administrative elementary department and finance transmission of the files are going on. Instead of, my lord, compliance of the order, two specific order, two mandamus had been issued, my lord. And the last, my lordship was also pleased to pass an order, my lord, on 23/4, wherein, my lord, today they are required to comply with the order, my lord. But, my lord, we have not received any salary till, my lord, more than a year, even after the order, my lord. So I think, my lord, personal appearance is justified. Otherwise, my lord, I don't think so, my lord, they are going to
Lordship,
culminate with a logical.
One IA is also
Yes,
being
yes,
filed.
IA, my lord, we have filed to
For implement of the
implement
finance.
of the finance commissioner, my lord.
Finance. That is
As a,
required.
that is required, my lord, that I am agreement with my respected friend. But, my lord, regarding the orders, without the implement also, they are proceeding, they are, my lord, assisting my lordships, my lord.
My lord, since they are a necessary party, it is prudent, my lord, to make them a party. And my lord, because my lord, if the regular process has to be followed to make them for proper compliance also, my lord. Everything, since he is so technical, my lord, the my lord, regarding the impediment, that thing has to be done, my lord. If the impediment is done, the finance department, my lord, will officially be there in the case, my lord. Because that's why the impediment has been filed, and they have filed the impediment, my lord, as per the notification of the thing. Today, my lord, let the impediment be, my lord, be allowed, and my lord, if they are, my lord, and
Yes,
then
Mr. Solia, what information is available with you?
Lordship, here we had raised some queries, Lordship, to the education department because we, the proposal was received by us and then we had raised the queries and then education department was supposed to revert back, Lordship, that the queries have not been addressed back because of which finance department cannot take the final call, Lordship. Lordship, we are just trying to follow the procedure, Lordship. In that procedure, Lordship, here, once the proposal was received, some queries are that is the duty of the finance department to see what all implications are there. And regarding that only, Lordship, the queries have been raised. Once they are met, Lordship, our hands are also tied, Lordship, till we get those queries so that we can proceed, Lordship.
Lordship, the last occasion, the finance department had said regarding the queries that have we taken the additional department's view or not? That instruction, my lord, the department is sent me, department, I mean, the government is sent me. I have placed it, my lord. That is the thing. I think already they have sent it to the irrigation department. So in compliance, my lord, to finance department's request to send it to the irrigation department, the education department has sent it to the irrigation department for the review. That is complied by the education department. I have placed it on record. My lord,
So now the matter is in the judicial department.
Yes, Lordship. Lordship, I handed.
copy also.
And Lordship, here, as per the instruction, they have endorsed the file to the judicial department on 30th of April, Lordship. Now, our difficulty is, since the file has not been reverted with the queries, Lordship, we cannot proceed, Lordship. That is the only difficulty. We are,
No, anybody from judicial department?
no, Lordship, the government, Lordship, judicial department.
No, not a party, but the one file is pending in the judicial department since 30th/4/2025. You can obtain instruction.
Lordship, because I am not the party here, Lordship.
No, you are not a party.
Lordship.
Now the question is, can you obtain instruction about the status of this file?
Lordship, they may implement us, Lordship. The file is before us, Lordship.
Your implement is not necessary in this
Lordship,
case.
Lordship. I will.
You are only to obtain instruction whether
Lordship.
the file is cleared or still pending in the judicial department.
Lordship, the status regarding that file.
Yes, yes.
Yes.
Mr. Pukan, you furnish a copy of this letter to Mr. Goswami.
Lordship.
And this file number is there.
Lordship.
So when you will be able to apprise this court about the status?
Monday, Lordship.
Next month.
Next Monday, Lordship.
Okay. In the meantime, we include the finance department.
My lord, the matter, my lord, the manner in which they are proceeding, my lord. The manner in which the files are being transmitted from this to that, my lord. Whether, my lord, this exercise has already been over, my lord. My service has already been provincialized. That provincialization order has not been interfered with by my lordships as well as by the department also, my lord. Without interfering the provincialization, they are saying that under the 2017 Act, myself as well as the private respondents are required to be provincialized. That's why, my lord, this honorable court says that once my initial provincialization order has not been interfered with, so therefore I am entitled to salary. Now, my lord, may kindly appreciate what they are doing. They are, my lord, revolving the file around to the finance, to the judicial. There is no requirement, my lord. Once there is a provincialization under the statute, I am entitled to my salary, my lord. That was the, my lord, finding of this honorable court. That's why the mandamus had been issued, my lord. This is only a delay tactics to, my lord, to float this honorable court's mandamus, my lord. That cannot be allowed, my lord. That's my humble.
Yes, Mr. Pukan.
My lord.
My lord, the last occasion that was sent, my lord, to my lord, judicial, the view come, my lord, actually, my lord, it is in process. They may not be impeachment may be allowed, my lord, and accordingly, they will, we will, my lord, bring an essay, as per last date, my lord, because the finance had placed the, my lord, instruction saying that it was whether we have given it to the, taken position already. That particular thing, my lord, we have complied, my lord. When the finance is complied, we have complied. Let the judicial view come.
No, regarding this contempt matter. Contempt matter, you were to comply with the order of this court. We are not concerned with the views of the judicial department.
I'm not directly, but I'm the repetition.
Now, my lord, in such a situation, my lord, if they are not going to comply with the order of this honorable court, the recourse of the law, my lord, from my limited knowledge is that they should prefer an appeal with the order which there is a direction. Until and unless that order is stayed, my lord, or modified, my lord, they are duty bound to comply. Now, the manner in which, my lord, they are transmitting with the file is just like behaving like an appellate authority, my lord. That is not permissible, my lord. I know, my lord, some queries are required, some correspondences are required. Had not there been my service being provincialized. Now, once provincialized, those exercises has already been over, my lord. That's my respectful submission. Now it's up to my lord.
Mr. Pukan, Why the order of the court could not be complied with? In contempt matter,
The contempt case, my lord, today it's connected, it has come connected, my lord. I am not in that case, my lord. I will have to go through, my lord. But my lord, my submission is, my lord, let the IAB, my lord, be allowed. Ultimately, my lord, it is in process, my lord. It takes time, my lord. These things take time. So, my lord, will allow us to get our instructions, my lord, because otherwise it will be difficult, my lord. It is difficult for us, my lord. We are
perhaps you are mixing the matter of this writ petition and the contempt case together.
Mal. Contempt was
My
there.
lord will.
Your instruction, this relates to the writ petition.
No, then I will let me, my lord, get my instructions as per the contempt also, my lord, because my lord, for the writ petition for item number 7, my lord, I have placed that particular instruction, my lord. Because on the last occasion, my lord had given that.
Okay, let it be on Monday then.
Mal.
Let us see, my lord.
Heard Mr. A.R. Bhuya,
Next Monday.
for the applicant and applicant. This interlocutory application is preferred by the applicant for implement of the commissioner and secretary to the Dr. Basam, Finance Department as respondent number 10 in the writ petition number 5620 of 2022. So Bhuya, learning counsel for the applicant submits that in the WPC number so and so, the finance department has not been completed as respondent. And in order to adjudicate the matter, implement of the finance department is necessary as respondent number 10 in the writ petition number so and so. Accordingly, taking note of the submission of Mr. Bhuya, learned counsel for the applicant, this interlocutory application stands allowed. The finance department being treated as respondent number 10 in WPC number so and so. Accordingly, this IA stands closed. Mr. Bhuya shall file amended cost title within 2 working days from today.
Mal.
This is a list the WPC number 5620 of 2022 on Monday.
Mal.
In contempt matter, heard Mr. Bhuya, learned counsel for the petitioner, and also heard Mr. Putan. You are for the respondent.
My lord, I'll check it.
Respondent.
Contempt.
Contempt. During the course of hearing, Mr. Kupon has produced a letter of the secretary to the Governor of Assam Department of School Education, dated 9/5/2025, and submits that the concerned file has been sent to the Judicial Department for seeking their views. It appears from the aforementioned letter that the file was transmitted to the Judicial Department on 30/4/2025. And in that view of the matter, Mr. J.K. Goswami, learned additional senior government advocate, is requested to obtain up-to-date status of this file, being file number 228806, and apprise this court on Monday about the status of the same.
My lord, there is an interim order in the writ petition that may kindly.
Interim order person writ petition shall.
Mal. Oblige, my lord.
Your order may be furnished.
Download for them.
Copy of?
A copy of order maybe.
Okay. A copy of the order we downloaded from the website and we furnished to Mr. Goswami during the course of the day.
My
lord, in the contempt matter, our names are not reflected, my lord. That is why we are not aware of it. Yes, contempt, my lord.
SMT.
Notice has not gone, my lord. I think. Notice. Because, my lord, kindly see the first list, my lord. It's only the private respondents' names are showing. Not the other parties. The
19/2 order.
Okay, we'll see.
19 February order.
My lord, in contempt case, my lord, notice is issued on 19/2, my lord.
19/2 order of the.
And SMT Chisti appeared, my lord, last occasion.
Okay, my lord.
Oblige, my lord.
Coming item 9.
Well, in this case, Upamina, he said that he has some difficulties, so at 2 he only able to, but at 2 my difficulties, where I have some rituals in my home, my lord, so this is the problem. So he is also saying that they are not going to file any my lord counter, so this matter come up for final hearing on Tuesday, my lord.
Next Tuesday.
Tuesday, my lord, as part of my lord.
Part Mr. Mohanto, learned counsel for the petitioner. Then Mr. A. Samoa, learned standing counsel for VPC, respondent number 3. And
Idas on behalf of the Upamana.
the Upamana, learned standing counsel for the respondent in Higher Education Department. And you?
P. Agarwal for UGC.
UGC A. Samoa appeared.
What?
Mr. A. Samoa
No,
already.
in this case, my lord, Agarwal is there. He is not, Soma is not there, my lord, in this case. Other is there.
Okay. Okay. In this matter, Mr. Samoa is not there. Okay.
Agarwal is there.
As agreed by learned advocates of both the parties, recessal is the matter of Tuesday.
And pleadings is complete, my lord.
I've already submitted the letter of leave for absence. 16 to 21.
Then, my lord, Thursday, my lord. If it is not possible on Tuesday, my lord, on Thursday, my lord. That is on my lord, 22nd. Yes, ma'am. Well, as pleadings is complete, my lord, that may be, my lord.
Okay. It is submitted at the bar that pleadings have already been completed. And as such, recessal is the matter for admission hearing.
It will be a part of the. Part of.
28. Timing 28.
28, my lord, my part is completed, my lord. Only Upon we have to complete this part. So he is saying that he is coming.
Milord, can we come up after a while, Milord?
Memo for Jazz.
Milord,
Let's look at for
List is exhausted already. List is exhausted. Lordship also, I think that is a problem.
Milord, at 12:30, like that, Milord.
12:30. Okay, all right.
Bas.
No partners.
Not complete, UGC complete. Meeting is.
At 12:30. Pending item 25.
So my consensus, my lord, I could not go through the file yesterday and I think he also needs to go through the
My lord,
records.
we have received the original record, my lord. I have to go through, my lord. Today is listed after so many days, my lord. Maybe fix another next week or any date, my lord, hearing day, my lord.
Okay. Convenience. As agreed by learned advocates of both the parties, recessal is the matter on second week of June.
My lord.
Second week of June.
My lord.
Timing item 26.
The 26, the pleadings are complete and can be taken up for disposal today itself. It's an admitted position that they will come up with. I'll show from the affidavit. Matter can be disposed of today if lordship takes.
Both the parties are represented by their counsel. It is submitted at the bar that pleadings have already been completed and the matter may be listed for admission.
I was
hearing.
praying that it can be heard today, my lord. It can be heard today, I was heard, whatever.
Pardon?
It can be heard today if it can be heard today, my lord.
Today?
Today, it's a very short issue, my lord.
And that's
I-
all right. I am ready.
My lord?
I am ready.
My lord is, then I listen. But here the case relates to selection and appointment in the Assam Industrial Security Force. Now, lordship would find at page 23 is the advertisement. The first para would be necessary. Page 23, lordship has.
Yes.
Recruitment rallies will be conducted for selection of candidates for filling up of 145 posts of constables in AI Assam Industrial Security Force from SPO who had worked in Dhubri and BTAD during 2012 ethnic problem, and the SPOs were deployed in the districts of Bongaigaon, Chirang, Baksa, NC Hills for national highways and railways line security during militancy in the payment of so and so. So this was a restricted
selection process being conducted for certain class of people who belong to SPOs and served as given in the advertisement. If Lordship should come 2 pages behind that from at page 19, 20 is the original. This is for petitioner number 1. There are 2 petitioners. Now, this is for petitioner number 1, which says that this is to certify that so-and-so homeguard was working in Baksa DF as SPO. So he worked as an SPO, and at page 21, Lordship will find for the second petitioner. So we fulfilled the conditions. We accordingly applied. We participated in the selection process. Now, in the advertisement, if Lordship has page 29, how the marks were required to be given. There is dispute to only one part of the mark at page 29. Here, Lordship would find the breakup of marks awarded for extracurricular activities and special skills, which is of maximum 40 marks, shall be as follows. Experience as homeguard. 1 year experience will earn 1 mark in each qualifying year. Then Lordship will find experience as SPO will earn 2 marks for each qualifying 1 year. It will not exceed 10 marks. This is where the controversy is. The rest of the marks as given, we are not disputing anything on that. Now, what had happened is, Lordship would find the marks given to us at page 33, the first petitioner. Lordship finds? Down below, Lordship will find document verification with original extra academic experience is one of the column or one of the rows. On page 33, certificate, homeguard experience certificate, Lordship finds at page 33. First column is personal detail. The second row is the document verification with original mandatory document.
23 is the advertisement.
33, my lord. 233.
Yes.
Now, the first at the top is the personal detail part. The second starts with document verification with original. Third with the physical standard test. Then the medical, physical eligibility test, physical eligibility test long jump. The next one, document verification with original, extra academic achievement and extracurricular document. Total marks 40. Homeguard experience, they have given me 10 marks. There was no dispute on that. Qualification percentage, 0 marks. We don't dispute that. Now, Lordship will find experience as SPO, 5 years experience as SPO. They had given us 10 marks. And homeguard training certificate submitted. He got 2 marks. The total came to 20. Now, my lord, per their affidavit in opposition, which we are not disputing, these marks can be taken to be correct. First petitioner loses the case. We had said that we should have been awarded 12 marks. Their affidavit says no, the calculation will be whatever number of experience of years you have. Even if it exceeds 5 years, even if it is 6 years, total marks allotted is 10. You don't go beyond 10. We don't dispute that. So first petitioner is out. He will not get it. Now, Lordship will have page 34. The second petitioner makes a case. The same column I will be referring to. Homeguard experience certificate, 10 years and above experience, 10 marks. Experience as SPO, 2 marks were given. And homeguard advanced training certificate, 2 marks were given. So our case was that it cannot be 2 marks. It had to be 10 marks. It was wrongly given, is how we started the writ petition. Now, Lordship will have a look at their affidavit in opposition. What do they say? At running page 87 is their affidavit in opposition. Lordship has page 85 first. Para 8, just above the table I am reading, Miller. In para it I'll read. That with regard to statements made in paragraph 8, 10, and 11, the deponent states that the marks against extracurricular activity and special skills were awarded as per certificates submitted by the petitioners. In this regard, the performance slips along with the documents submitted by petitioner have been collected from commandant. As per records, it is found that both petitioners were already been awarded marks during the time of PST and TET. The marks secured by the candidates are as follows. Now here Lordship would find for the second petitioner, the total comes to 39.5. This we disputed. Now Lordship would turn to page 87. I'll read from the top, my lord. Considering the records received from the Superintendent of Police, both candidates, namely Biju Kumar Lahari and Binoy Boro, should have been awarded 10 marks as they rendered more than 5 years of service as SPO Home Guard. Hence, 10 marks for both should be considered correct. What had happened is they took my experience as 1 year instead of 5 years. So I got 2 marks. Had it been 5 years, I would have got 10 marks. The table below shows that, my lord. Lordship will find the total comes to 47.5. So instead of 39.5, the second petitioner now goes up to 47.5. That is the admitted position. That is what should have been correct for the petition number 2. Then Lordship should have page 103. 109, I'm sorry, my lord. It is a part of their affidavit in opposition. How this mistake happened? Page 109, this is to the nodal officer from the commandant. The last paragraph. That, sir, now at present it is difficult for us to ascertain the exact cause of discrepancy in obtaining marks by Biju Kumar Lahari and Binoy Boro against the same standard of SPO experience certificate. Perhaps it may be due to human error or wrong entries made in the final document. So as the position stands now, the petition number 2 would have scored 47.5. We have given in the affidavit in reply, which would be at page 117, Lordship will find, is the result of one of the candidates page 117. He is a caste, Lordship will find STP, my same caste. We both belong to STP. He is STP. Marks obtained, total marks obtained, Lordship will find is 45.50. So person who scored below me, who should have scored below me, 45.50 has been appointed. Lordship will find on the just immediately below, he was selected. So basing on the admitted error in awarding me marks to the second petitioner, seeing that he has scored above at least one of the selected candidates, our prayer would be, my lord, Lordship will have them corrected, direct them to correct my marks to 47.50 and declare me selected, give me consequential appointment at par with the persons who were selected in that selection process. For that, my lord, if I just refer to 1 or 2 of the judgments of this honorable court, a division bench judgment. Lordship should have page number 4, just above para 9. That being the situation at the end of the judgment. That being the situation, the case of the respondent herein is squarely covered by the ratio of the above judgment. Admittedly, candidates lower in merit to the respondent were selected and appointed in the very same selection process. Here, what had happened is this man missed out the appointment because they did not appoint him, although he had secured the cutoff mark. Initially, learned single judge had the repetition was allowed, and then the Union of India went up in appeal. This is the order in the appeal. Lordship would have para 10 thereafter. Resultantly, we hereby direct that the respondent shall be considered for appointment as a constable in the appropriate category as per the marks obtained by him, subject to his clearing the physical fitness or efficiency test. The appointment of the respondent subject to clearing the physical fitness test shall be made effective from the date on which the candidates lower in merit to him were appointed in service. However, the respondent shall be entitled to notional monetary benefits from the date on which such candidates were appointed. Actual financial benefits shall accrue to the respondent from the date he joins the post. This really being granted to us, my lord, after they correct my marks, which admittedly was a human error on their part. Petitioner number 2 would be entitled to relief. Petitioner number 1 would not have any relief because he secured 44 marks, which is just below the cutoff of 45.5. That is how that's the case of the petitions.
Yes, Mr. Wilson.
Lordship, kindly see Lordship page 88, running page 88, Lordship, in my affidavit, Lordship. Lordship, that in regards to the statement made in the writ petition, the deponent stated that in compliance with the order dated 10/05/2024, the Honorable Guwahati High Court, an exercise was conducted to allot 2 marks against the certificates of the writ petitioner whose period of service either as homeguard or SPOs was not specified in the respective certificate submitted by the petitioners during that time, PST and PET, Lordship. The judgment I refer, Lordship. Paragraphs. Regarding SPO, Lordship, in this judgment, Lordship, Honorable Court directed us that to give the 2 marks wherein the certificate is not defined the period, Lordship. Is Lordship, paragraphs 3, 4, 5, and 6, Lordship. Second last page, Lordship. Judgment of the coordinate bench, Lordship. Herein, Lordship, it's been paragraph 6, Lordship. The court is the considered opinion that the aforesaid consents would serve the interest of the justice inasmuch as some of the petitioners contend that they have missed the cutoff marks by a very less margin. In view of the above, the case of the petitioner as directed to be reconsidered by allotting 2 marks of such certificates wherein the period of service either as homeguards or SPO has not been specified in the respective certificates, and if it is found that the petitioners are within the zone of the consideration and has secured more than the cutoff marks secured by the last appointed candidate, the benefit of the appointment should be given to them, Lordship. Here, the ratio is that, Lordship. If in the certificates, Lordship, the specific period is not defined, Lordship, then the Honorable Court directed us that to give 2 marks, Lordship, for each candidate, Lordship. Herein, Lordship, the certificate which is placed before the petitioner, Lordship, in their case, Lordship, the period is not defined, Lordship. And therefore, as per the instruction, Lordship, it appears that, Lordship, after considering this order, Lordship, they obtain the petitioner number 2 obtain 2 marks, Lordship. Because in their certificate at the time of PSC, Lordship, they produce the certificate wherein the specific period is not defined, Lordship. That is my humble submission, Lordship. This Biju Kumar, no?
Okay,
Binoy Bodo, Lordship, page number 107, Lordship. That is his certificate, Lordship.
we'll pass the order.
Lordship.
Just one thing at this point of my lord. The part that was the other judgment that has been referred to was a judgment in personam because lordship will find the cases of the petitioners are required to be directed. Those who were writ petitioners for in that judgment, this 2 marks allotment was restricted to only them. In so far as our case goes, the admitted position in the affidavit in the position that I am entitled to 10 marks.
Okay.
This judgment at page 72, lordship will find I have annexed the judgment also. In view of the above, the cases of the petitioners, I am not a petitioner in that case. I was not a petitioner because there the entire issue was different, not about allotting this 10 marks or which I had claimed. My particular case in their affidavit, they admit that he is entitled to 10 marks. So that being a judgment in personam for the petitioners who were before the honorable court in that judgment will not apply to me per se. It is their affidavit in opposition. Had they taken a stand that yes, we acted according to that judgment, I would have been on a different footing. Their affidavit does not say so.
No, in paragraphs 9, I submitted, Lordship.
Para 7 clearly in the judgment,
Para
page
7
72, in
is the-
view of the above, the case of the petitioners are directed to be reconsidered. And if you can show that I was a petitioner there, this judgment will apply to me.
No, but
It is not that all the candidates who are before this court or not before this court, you allot 2 marks. Was never the stand of the court. Those petitioners were satisfied with the 2 marks. They were. In my case, they admit 10 marks is what you want. You should have got. Thank you. Give me the 10 marks. That is where I would stand.
Okay.
Obliged. Only the petitioner number 2 would have a case. Obliged.